What are the mechanics of implementing source code escrow? There are usually some standard documents to put in place, or I should say documents that are always present when we do source code escrow, though they themselves vary quite a bit. There is ordinarily a commitment in a license agreement to place source code in escrow or to enter into a separate escrow agreement. Those escrow agreements may be two-party or three-party, that is, an agreement that exists between the licensor and an escrow agent, or an agreement that exists among the licensor, the escrow agent, and the licensee. That three-party agreement is perhaps more common and certainly preferable to licensees. When that agreement is entered, there is a commitment to place certain materials into a depository account with the escrow agent, and the escrow agent will agree to hold on to those materials in exchange for compensation spelled out in the agreement, and the escrow agent will agree to release those materials or a copy of those materials to the beneficiary that's named in the agreement, ordinarily this licensee, and only upon the occurrence of certain trigger events that are ordinarily listed in the agreement, though not necessarily. It can be that the escrow agent itself will determine whether trigger events have occurred, or there is more commonly simply a process that is followed. Usually it's a process by which the licensee will send notice to the escrow agent indicating that it believes a trigger event, a release event, has occurred. And if the licensor does not object after some period of time, a short period, the escrow agent will release the escrow materials to the licensee. If the licensor does object, perhaps the licensor contends that the release event has not occurred, then these agreements ordinarily spell out a dispute resolution process, such as an expedited arbitration proceeding, to determine whether the licensee rightfully should obtain a copy of the escrow materials. Once the escrow materials have been released, then there are rights that go to the licensee, and those may be spelled out in the escrow agreement itself, or they may be spelled out in the original license agreement, which might indicate what should happen should the escrow materials ever come into the possession of the licensee. And those are the rights that the licensee will have with respect to the escrowed materials. Those rights may differ from the set of rights that attach to the object code form of the software, which were the subject of the original license agreement itself. Once the escrowed materials have been released, ordinarily that's the end of the escrow relationship and the escrow agreement terminates, unless it's a master escrow relationship where a single agent holds on to a set of deposit materials for the benefit of numerous beneficiaries, in which case whenever there's a triggering event, only a copy is released to a particular beneficiary and the agreement remains in place between the licensor and the agent. That's the mechanics of software escrow.